SJC-12921, Seth Doull v. Anna C. Foster.
Okay. And for the appellant, please. You may give, maybe, good morning, counsel, you may begin.
Good morning, Justices. May it please the court. My name is Chris Sobchak and I represent the plaintiffs, the Doull family, both at the trial and here before this honorable court. This is a medical malpractice case where the defendants, for years, negligently treated Laura Doull, where by prescribing to her without informed consent a unproven, untested hormone replacement therapy, which then she developed a VTE and PEs, and then for weeks, if not months, failed to ignore the signs and symptoms of those PEs that led to the development of CTEPH, and which then led to her premature and painful death at the age of 43. Now, after weeks of trial and evidence and over 20 hours of deliberation, the jury found that both the defendants, separately and individually, were negligent, but neither one was the sole or but-for cause of harm because of the wrong instructions by the trial court. Now, the result was prejudicial to the plaintiffs, but not surprising, because all the evidence demonstrated that the multiple and separate instances of the defendant's negligence each were likely significant contributing causes to the harm, but likewise, each were likely never the sole or but-for cause, given the plaintiff's own medical history. Now, defendants essentially conceded as much in their brief, claiming that the substantial contributing factor instruction is the proper law of the Massachusetts, but in this case it didn't apply because they claim there's only one cause. And even the trial court conceded that there were multiple causes here, because the court first instructed that there were multiple defendants, and then when the defendants asked for their natural cause of the disease instruction, the court noted that this could be a problematic for their sole cause instruction, but yet the court still instructed on the but cause instruction. Now, this honorable court, in taking up the case, asked whether the substantial contributing factor may or must be used in lieu of the but for instruction. And the plaintiffs respectfully suggest that the answer should be a clear must, because to avoid such injustice in the future, because the substantial contributing factor instruction is not only fairer, but it's also universally and standardly applicable to all cases, and has been used without an error in the Commonwealth for about 100 years. As highlighted by both the MATA amicus brief and the fact that neither the MDLA's brief nor the defendants were able to find to a single instance in the Commonwealth where the substantial contributing factor has been used incorrectly or required reversal.
Counsel, could you ask you a question?
Yes,
Seems to me that the appellees are arguing that the court should adopt sections 26 and 27 of the restatement third to provide much needed clarity and uniformity in the law. What do you think about that?
I think it would be a horrible idea, Your Justice. It's the substantial contributing factor is the clearer of the two instructions. The but for, as addressed in the amicus brief of the MATA, is more confusing and may occasionally apply to an instance where there is no other contributing factors. But even in a situation where there is on paper a single but for cause, the substantial contributing factor would still apply. And yet, if you use the but for, and there are other things that could potentially be leading to it, it would lead to an improper verdict. And even in an instance where you have, as highlighted in the brief, where you have a healthy plaintiff being hit by a car that's completely unobstructed and then it injures the person, there would be jurors that may say, well, the car was not the sole but for cause, because had the plaintiff not left that day, he would have not got hurt. So using the but for,
that defies our common sense and our experience as former trial judges and appellate judges. As the judge said, and we've said on a number of occasions, in the ordinary case, but for is fine. That's our present case law, correct?
The current case law is that but for can be used, but there's also no case law that says that you can use a substantial contributing factor when but for applies.
So your answer to my question is yes, correct?
Correct. There are instances.
All right, let me ask you a different question. So here, the judge had the discretion to give either. We've never said as a matter of law, substantial contributing factor is required, correct?
Not exactly, Your Honor. There is correct. There is no case law that says you must given. However, there is also no case law that says we have instances where you have multiple causes or multiple tortfeasors, but for is the proper.
Well, let me ask you about the multiple tortfeasors. In this case, we have a nurse practitioner and a supervising physician. I understand your argument that the physician had a responsibility above and beyond what the nurse practitioner did. But in a traditional respondeat superior case, where you have an attendant and a fellow, for instance, and the attendant never sees the patient, wouldn't that be an instance where multiple tortfeasors wouldn't matter? So if you had respondeat superior, you could use but-for?
In an instance where the second defendant's responsibilities solely as respondent superior, I agree you could narrow it down to a single instance. That's not the case here. The doctor had an independent duty, the doctor had an independent applicability, and there's also the third defendant, the drug itself and the company that made it.
Let me ask you a different question. This will be my last question. In the brief you filed, you accuse a experienced and respected trial judge of doing the defendant's bidding. Do you think that's good appellate advocacy?
It may not be good advocacy. Unfortunately, on the face, it was the facts. I've seen this brief for 10 years, and not a single time it's been allowed, and that's why there is not a single appellate case that makes.
So we have lots of instances where we have hardworking trial judges who make a wrong legal call. Myself being one of them when I was a trial judge, and I've been reversed. But when you rule against one side, it's very rare and quite dramatic for the losing side to say the judge was essentially corrupt and doing the other side's bidding. Again, do you think that was a good move on your part?
I never claimed the judge was corrupt, and in this case, it had to be, because this was not a single instance. As I outlined, in almost every single aspect of the trial court, the judge has went for defense.
Well, you were also sanctioned under Rule 11, and then you apologized. My last, I guess, remark and not question is, I guess your contrition didn't last very long. If my colleagues have other questions.
Well, may I address that comment? Because that's actually on appeal as well. There was no sanction in Rule 11. The sanction was reversed. I apologize to somebody else. And the issue was that the defendants have asked for multiple requests. I asked for a speedy trial. The court, without any kind of process.
There's a different question before you. Justice Kafka?
Your brief is filled with references to the sole but-for cause or the sole cause. Did the judge ever use the word sole? Because my understanding is there can be multiple but-for causes. So did the judge, I'd like you to give me an example in the instructions where the judge uses the word sole.
I'll pull up in a second, but I do believe the judge did use sole and but-for, as that's asked for the defendants in the brief.
Because the restatement third instruction talks about there could be multiple but-for causes, right?
The restatement third in the comments 27 refers to potential multiple causes. That's not what the
multiple but-for causes, right?
Not specifically. That's the second issue. But-for means had this one defendant not committed negligence, the but-for the cause is broken. So
can I ask another? So I'm not sure if the judge does use the word sole, I'm interested in it, but the second problem I have is it's a question I think Justice Gaziano was probing, and I still don't get it. The only person who saw your client is the nurse, correct? So how could this issue that you're talking about, as a practical matter, explain to me how the jury could be confused between substantial contributing and but-for in this factual situation where the nurse is the only one providing treatment. How could the jury, why would it make a difference under either standard here?
Well, address it two ways. And physically, the nurse was the only one providing treatment in the last few months. But my client was the patient of the doctor's practice since she was 12. So the doctor was seeing her all along.
Bear with me. Tell me how a jury, just to walk me through, I just don't understand it. How could the jury have, if the jury were given a different instruction here, why would it matter given the fact that the nurse is the only one treating your client during the relevant time period? I just don't understand. Tell me how, if you were a juror, how you would have been confused by this.
Confusion led from the other causes, not just the number of defendants, but where the harm came from. So in this case, the drug itself was a cause because it led to an increase in blood clotting. The delay in the testing was a separate cause. As the defendants tried to argue, the natural progression of my client's own clotting disorder was a cause. In medical malpractice, rarely is a single instance or a single instance of negligence the sole but for cause. It's usually a myriad of conditions combined that lead to a harm. Here was the perfect example. My client had a blood clotting disorder that's been proven by her platelet counts that were ignored for years but fell outside of statute of repose. That in itself.
Understand if I could, I don't understand how that isn't covered by the instruction that was given. You're saying that the deviation from the standard of care involved a delay in diagnosis and testing, and also the decision to prescribe the compound. If those two acts are a but-for cause, if that alleged deviation is a but-for cause, then there'd be negligence. As far as the underlying illness is concerned, I don't know if there was an eggshell skull request, but more simply, the doctor takes the patient as he or she finds the patient, and I don't understand how that's not covered by the instruction that was given.
There was an eggshell skull request. It was not given, and in a conjunction with that, the defendants actually requested for instruction about the natural cause of the disease, saying that the patient would have gotten worse regardless of any negligence. That in itself is a separate cause. That's why it was not covered by the instruction, because when the court overemphasized the sole but for cause of the defendant's negligence, when there were multiple different instances of negligence and multiple defendants with independent duties, the jury could not find causation. That's why it took them over 20 hours and came back with a split verdict.
You keep on saying independent duties, but as has been mentioned now 2 times, the nature of the alleged deviation from the standard of care, the underlying deviation is the same for the nurse practitioner and the doctor. We don't have a situation where you have multiple tortfeasors who each contribute to a cause and each would have independently caused the damages. You have a situation here where the nature of the deviation is the same, even though one is in a supervisory position, isn't it?
No, Your Justice, because the doctor has an independent duty. My client was a patient of the practice, so when she called in the spring and went to complain with shortness of breath, it was one or the other that would have seen her. It just happened to be that in this case, the nurse practitioner saw her.
I understand it's an independent duty. It's an independent duty to do the same thing that you say was the cause that flowed from the deviation, the failure to diagnose, test early enough, and the prescription. It's the same thing, that you don't have different causes. You have 2 different alleged tortfeasors, but it's the same deviation.
It's different deviation. The delayed diagnosis is in the spring. That happens 3-4 years later after she's already been on these drugs. The initial deviation, because of the statute of repose, is the actual prescribing of the drug and not following the trial. Those are 2 separate independent causes. You could have had a estrogen therapy or a hormone replacement therapy and kept track of it, and it could actually be beneficial to the patient. Many women take estrogen or other hormone replacement therapy. But the issue is, one, when you put her on it without the informing consent of what it could do to her, and then you didn't follow it and potentially taper it, that in itself contributes to her harm. And then secondly, and independently, when that harm actually materialized and she started developing those PEs in her lungs and was having trouble breathing for months, and as considered by their own experts, that when she was finally came in May, some of those clusters in her lungs have been there for months before. Both the doctor and the nurse practitioner had a duty to identify it and do something to it. And if the nurse practitioner, who may have had a lower level of training and skill, was missing it, then the doctor should have. You don't just say, well, your shortness of breath is caused by candles. You have her on a hormone replacement therapy. You have a history of a clotting disorder. And here she is having a repeated shortness of breath issues. That is a separate issue that, according to both the doctors that treated her and the plaintiff's expert was an independent contributing cause to what ultimately led to her seat theft and her death.
Any other questions?
Sure, thank you, Justice Link. Substantial contributing cause, which grew out of O'Connor and toxic torts, there's concerns that led actually to the third restatement of torts moving away from the substantial contributing cause, that it infuses tremendous discretion, subjectivity into the instruction. Doesn't it?
It doesn't. It's actually is more precise because it allows for the jury to decide, is it a cause or not? There are, I can't think of a single instance, and I know the court's already said there have been instances where but for is correct, but there are instances where things contribute in different degree. The jury decides what's significant, just like jury decides what's the standard. It gives the juries the option of, here's what happened, here are all the potential tortfeasors, here are the potential causes, here are the ones that are before you. You decide which ones are ones that significantly contribute to the other result. Whereas if you use the sole but for, you're living in a situation where if somebody could have been negligent, could have contributed to the harm, but because they were not the sole but for cause, then you have an unjust result of no negligence and no causation because there was somebody else that contributed to it too. And on the early comment, I agree with the Mehta's brief that it's not a new construct of 30 years. It's been around for over 100 years. It's just been used in different language.
I'm sorry, you keep saying sole but for. And I looked at the instructions. I don't see sole in her instructions. She didn't say solely, she said but for. So isn't there a difference there? I mean, you keep putting them together and that's just not what the judge instructed.
But for is so. There's no other way to explain it.
No, it's not. No, it's not.
But for means without any other options.
Right, but
That's
but for means it was part of what happened. If there's more than one cause, that was one of them.
That's not what the judge instructed, and that's not what the argument by the other side was, and that's not what their closing argument was. It's but for means.
But that's because that wasn't the case. That wasn't the situation in this case. That's why they didn't argue it.
They did argue it, and
I'm done. No, I'm sorry. I'm done. I don't have any more questions.
Any more questions? No? All right, Mr. Wygand, please. Let's hear from you.
Yes, may it please the court. Thank you very much. As the court has indicated through its questions, the primary question on appeal is whether the judge's instruction on causation in this medical malpractice was correct. I'd like to make 2 points this morning. One, there was no error in the judge's instruction in declining to substitute substantial factor with but for. And 2, even assuming you were to find that substantial factor should have been used, there was no showing that it was prejudicial given the state of the evidence at trial.
Let me ask you, Mr. Wygand, let me ask you a question about your theory below and what your theory is now. I read the jury request, and the jury request basically said, embrace restatement third. That's the way to go. It's more clear. So we have the instructions, and we've all read them. Then there's a motion for new trial. One of the issues in the motion for new trial is this causation issue. And the judge essentially, and correct me if I'm wrong, says, I know I had the option to use substantial contributing factor or but for. In the ordinary case, I would use but for. This was an ordinary case because of the illness and the facts surrounding that. You don't argue that in your appeal. You seem to walk away from this was an ordinary case. And now you make an argument, which we'll get into, about why this wasn't prejudicial error, if error at all. But have you walked away from the judge's findings on the motion for new trial?
Well, I don't think it's inconsistent with what we are saying. You know, she said, if she's saying that you could use either, keep in mind that in most instances, particularly through the language of the second restatement, that substantial contributing cause is defined by subsuming but for. So the jury is told that in order therefore to be cause, the cause has to be substantial and without which it would not have occurred. So, but it's in trying to be responsive to your question, I think this is a case where but-for applies because substantial factor, when used as an exception, is for multiple sufficient causes or independent concurrent causes, and that wasn't present here.
But just taking a simple example of concurrent causes, we have one alleged harm is prescribing the compound. Then the other alleged harm or negligence is that when she presented with the shortness of breath, is not sending her out for further testing, basically saying it has to do with a pre-existing condition and not catching the blood clots. Aren't those two independent causes?
No, not in the context of this
Or
case.
independent acts of negligence?
There was no independent theory of negligence that you were negligent in prescribing the progesterone cream. The claim was you didn't provide informed consent, which was a separate claim, and the jury found that there was no violation of that duty. But to the extent you're saying that there was a question of what was the cause of the clotting, that it either came from the cream or that it was this underlying CTEPH disease, and therefore together with the defendant's alleged negligence in not referring earlier, and that is supposed to be a concurring cause, my answer to that is it's not. Keep in mind, this is a failure to intervene in a timely fashion. They're saying that in those spring visits, they should have referred her, and that earlier treatment would have prevented the stroke and their death. That is not a concurrent cause situation where it has been recognized that substantial factor may be a better factual test. And it's a limited circumstance. This is a failure to intervene. The famous case, as you know, is the Anderson case, the twin fires that merge and destroy a property. Two sufficient causes. And the concern is that neither fire will be found responsible because of the other. And they felt it was unjust, and so emerged this language of substantial factor. Change the facts to what we have here. Say in that twin fire situation, the claim was the fire department didn't arrive in time. And if it had, it would have prevented the property from being destroyed. That's what and that but-for would apply in that case. It's not a concurrent cause case. It's whether or not the intervention would have prevented the harm. And we have that here.
What about multiple tortfeasors? Here we have a nurse practitioner and a supervising physician, and the claim is the supervising physician, apart from responding at superior, had independent duties other than that which the nurse practitioner had. How do you respond to the joint tortfeasor issue?
Yes, he may have had an independent duty. His independent duty was as supervisor. That was how it was tried. The plaintiff took the position that he violated his duty in his supervision of the nurse practitioner. And it was all directed that if he had done his job, she would have diagnosed or referred out during those spring visits and therefore gotten treatment and therefore supposedly would have prevented the decedent's death. So what I'm saying is, while it's an independent duty, there are no separate causal pathways from Dr. Miller to the plaintiff without going through the nurse practitioner. This is what the judge agreed to. There was one cause, the nurse practitioner's failure. Now, he may have an independent duty to make sure she was supposed to do what she was supposed to do, but it's not a concurrent cause. It's a single cause. And the judge recognized it. It was discussion on the record, and but-for applies. I'd come back to this. I think an important aspect of this case is that it's a failure to diagnose. And we shouldn't fritter away the but-for test. That is a fundamental aspect of legal responsibility.
Okay,
Can I ask?
Justice Kafka has a question, please.
Mr. Wagon, so I want to clarify, did the judge use the word sole but for? Did she ever use the word, or I can't remember the judge now, is sole?
Roop, is Judge Roop?
Judge Roop, did she ever use the term sole but
No.
for? So this whole sole is just interjected by the plaintiff's brief, is that right?
Yeah, there was no language of soul. And in fact, if you look at the instruction, there's a portion near the end where she makes very clear. She tells the jury, listen, you are to independently and separately evaluate each defendant. And then
Okay,
what you
that's-
find as to one is not controlling on the other.
That's where I get, this is really conceptually difficult. So I'm meaning, but for a juror to understand, those of us who, I mean, it brings back bad memories of tort class. So but for, I understand how it can create some confusion though about how you have two but for causes, right? How does a jury understand that there can be two but for defendants?
Yes, I think that's a fair question. I think it's an easier answer than you think.
Go
And
ahead.
that's-
It would help me because I don't find it that easy myself.
Okay, yeah, no. Again, the fact that the judge instructed that you look at each one of these independently and separately. So whatever you decide as defendant A, it's not controlling as defendant B. So under the third restatement, for instance, section 27 makes expressly clear there can be more than one but for cause. And so how you convey that to the jury is you might have multiple defendants, but you tell the jury you are to assess each defendant's conduct causally, individually, and without regard to what you find as to another defendant. Just because you find one defendant was not a but-for cause has no impact on whether the remaining defendants were a but-for cause.
So give me, in the facts of this case, where you've got the nurse is the only person seeing him, seeing her. So the judge gives the instruction. How would a juror conceptually analyze the doctor's role here? So the nurse is, I understand how you could find that the nurse is a but-for cause. How does the jury understand, okay, if the nurse is a but-for cause, how could the doctor also be a but-for cause? I know it's opposite of the jury result, but I'm just trying conceptually, how would that work in a juror's head?
Yeah, well, it would work this way. If they couldn't find Dr. Miller to be a but-for cause or a substantial contributing cause if they didn't find the nurse was, because the theory was he didn't supervise her to make sure she did what she was supposed to. So the analysis would be that they would have to find her to be a but-for cause and then ask, did he fail in his supervision of her?
Meaning,
And if they,
so she was a but-for cause because but for the treatment she provided. I get that part. And then but for his failure to, because he had duty, I'm not saying this is, I'm just trying to make sure I understand, because the judge gives this instruction, so I want to make sure it makes sense, even though the jury decides the doctor isn't liable. So the doctor could be liable even if she's a but-for cause, because but for his failure to supervise, it would still have been prevented. Is that the idea?
right, he failed in his supervision of the nurse practitioner to ensure that she referred for treatment.
Right. So you could have two multiple but-for causes here. So the instruction was proper because it's possible under these circumstances. Whether a jury who hasn't been to law school understands this is a whole nother story. But okay, I got you. Mm-hmm.
But I think on that, Judge, is that the jury here, the way the case was tried, they understood the causal question, which really was, would earlier intervention have made any difference? And that they knew that. The defense was it wouldn't have because of the nature of this clotting disorder.
I understand how a jury understands a substantial contributing cause because it's layman's terminology. But I have a little, and I understand also the restatement may be a much more precise, but it may be just so complicated. I'm just wondering if it works in the real world. But that's I'm talking to myself, so I have no further questions.
Okay. I think that what shouldn't be lost on this is that irregardless of whether you believe that substantial factor should have been substituted for but for, it has been no showing of any prejudice here
Before you get
at
into
all.
prejudice, Mr. Wygod, I want to talk for a moment about the amicus brief and the concern about substantial contributing cause in general. If I could just ask you a yes or no question, though. Do you agree with the amicus brief that substantial contributing cause should not be part of the instructions in any case?
I believe that there's two schools of thought on that, Judge, and they both have some validity. One being that the proper use of substantial contributing cause works well. And there's the restatement third view that says, you know what, it's more trouble than it's worth. It's evaluative. Causation is not one of degree. We think the language should be taken out. So it's hard for me. Like I said, I don't believe you need to decide or adopt the third restatement to decide.
No, I understand and appreciate that point. Nonetheless, I just want to, because it's in front of us, and this is an area of confusion that I remember having myself when I was in the Superior Court. But the restatement third, section 27 talks about if multiple acts, each of which alone would have been the factual cause of harm in the absence of the other, then you have legal cause. But what section 27 doesn't take into account, and where substantial contributing cause may make sense, is if no one specific breach of the duty of care would have caused the incident, but a number of deviations together would, and without one of them, there wouldn't have been causation. Why wouldn't substantial contributing cause work in that situation, and why isn't it necessary as opposed to but for?
Yeah, I think the third restatement does cover that, Judge. It's under the notion of sufficient causal sets. So if in the asbestos case, you know, even if you were just a small contribution, but it was necessary to trigger the disease, everybody that was in that necessary causal set is a factual cause of the harm.
Okay, if I could just follow up on that. Let's just, I know that the prescription of the drug is pled and the gravamen is a informed consent. But let's say that the deviation here was more precise, that it's not just the failure to a delay in diagnosis, it's also the prescribing of the compound, and that neither individually may have led to the damages, but together they did. Would substantial contributing cause have any application in that situation?
When I hear that question, you're almost saying different theories of liability. They're different theories of liability. Each would have to be assessed as to whether they were without, you know, under a but-for analysis would still apply. I don't see them as a multiple sufficient cause situation where, you know, substantial factor has played a role. Keep in mind that what I think is some of the confusion with substantial contributing cause is that it's kind of taken over the show. It only evolved to deal with that discrete situation of the twin fires, multiple sufficient. And under the second restatement, it's defined specifically to assume but for. So when a trial judge gives an instruction using substantial factor, saying the conduct has to be substantial and without which it would not have occurred, there's no material difference with the third restatement or just using but for. But it's when judges get confused and just sort of say, it's just needs to be a substantial contributing cause because we have multiple defendants or multiple causes. That's a misuse.
Thank you.
You got to remember, it's limited to these discrete circumstances. O'Connor, that complicated asbestos where you got this inextricable tangle, and then you have the multiple sufficient cause. But beyond that, but for is fundamental to our system and legal responsibility, and we've got to be careful that we don't fritter away unnecessarily under what can be a difficult concept or a term to understand. I guess I'd come back to the I think, which is a compelling argument.
I think is there any more questions? No more questions? I think your time is up, Mr. Wygand.
All right, thank you very much.
All right, thank you very much.